Okay, so we should now be recording. This is the last online section. It's Tuesday, December 11th. Your exam, your final exam will be up and available to you tomorrow at 8 a.m. and it will be up and available until 10 p.m. Sunday. That Sunday date and time is a drop dead date as far as I'm concerned. I'd accept no work after that date. And I would advise all of you to try and, if you're going to wait till Sunday to take the exam, take it as early as possible, because if you have problems with the computer or blinking off or something, you may not be able to get back on before the exam comes back down. So just kind of keep that in mind. And by the way, the earlier you can get this accomplished, the earlier you're done with the course, and you don't have to deal with me anymore. And the earlier I can get grades out. I have to have grades in by, I believe it's Wednesday. And let me just look at the date real here. I believe it's Wednesday the 19th, if I'm not mistaken, before noon. And I would really like the last day the exam will be available is the 16th, and I'd really like to get them in very early Monday morning if possible. So, and I want to be done with the course too. Okay. One other thing I would like for everybody to, will I be posting this lecture online? Yes, I do. I will be. Yes. So this lecture will be being recorded and will be posted online. I am doing that consistently now. So what I want to discuss tonight, and oh, what I do want to ask everyone to do is, as soon as possible, I think you may only have until the 13th or the 14th to do this, but as soon as possible, get online to the assessment sections and evaluate the course. It's very important that you do that with regard to one of the things I get evaluated on is how many of my students I get into I entice to getting into evaluating and doing an assessment. I probably send out an email urging you to do that, and maybe even suggesting if you do it before the deadline, before the 13th, you may get 10 extra bonus points or something. I can always bribe people with bonus points. That's the thing about instructors. Okay. All right. And so please do that. And if I would appreciate it, and any positive feedback is always appreciated, but also anything that I think can be considered constructive criticism is also thought highly of. And we do, Professor Beard and I do review these things and the comments, and we have made changes in the course based upon some of the suggestions. And one of the issues always is are there subjects that you thought should be covered that weren't, or subjects that we discussed that you thought were just totally useless? Which, yeah, for all, it's like occasionally someone says, "Oh, doggone course was," whatever. Okay. All right, questions? Anybody got any questions here before I go on? I really want to discuss Buffalo Creek real quick and get this done, and because I have to, since I do want to post this, I have to run to the library and use their computers to upload something as large as these files get to be. Okay, I don't see any other questions. All right, now I'm going to use a little bit tonight towards PowerPoint. I believe it's actually in part of the Buffalo Creek unit, if I'm not mistaken. And let me see, I think I have it open already. And if I can do my share properly, you should now see, I believe, towards PowerPoint, and this is page 23. It's pretty well far down on the PowerPoint. But what this PowerPoint illustrates is the elements of what we call a negligence cause of action. And we've been talking about negligence cause of actions almost from day one, when we were talking about a driver that was using a handheld while operating a motor vehicle, that driver owed a duty to exercise ordinary care and caution for the safety of others and their property and themselves, by the way. That when that distracted driver diverts his attention away from the roadway and hits the little old lady in the crosswalk, right? Because they're not exercising ordinary care and caution, that's a breach of that duty that is owed to all of us. That the little old lady suffers actual injury to herself and her property, her walker, and of course she suffers personal injuries. And lastly, the breach is in fact the cause, in fact, and what we call legal cause, proximate cause of the injury, but the two are rationally linked, and that there are some limitations as to foreseeability. That's beyond the scope of this course. So we've been discussing this idea of negligence, and we understand that if these elements are met, that someone breaches their duty to exercise ordinary care and caution, and another third party is injured, then you may have to pay them compensation. That's a negligence cause of action. And essentially that's what was going on in Buffalo Creek. The mine, Pittston ultimately, but Buffalo Creek, the executives Buffalo Creek Corporation owed a duty to exercise ordinary care and caution when operating the mine. That duty extended to the citizens of Buffalo Creek, that they breached that duty. And actually, how did they breach that duty? I mean, we understand what really should have happened here is there should have been an emergency spillway placed into the mine. I think that became clear that another Pittston company was operating a mine just a few miles away in the next valley, and that impoundment had an emergency overflow on it. That the failure to include an emergency overflow, I think, is clearly a failure to exercise ordinary care and caution, with the consensus being that if one had been installed, then the mine, the impoundment would not have been breached, and the incident would not have occurred. But because there was a failure, there was not one put in the impoundment, that failure ultimately led to the breach of the impoundment and the damages that flowed from that, the injury to the citizens and property of Buffalo Creek, which were downstream. Now, I want to next talk about the kinds of damages, and this is kind of getting into the meat of what you need to know for the exam, but we have this thing called compensatory damages, that in a negligence action, there actually has to be actual damage suffered by the injured party, that if there is no actual damage, there can be no claim for compensation in a negligence cause of action. And as we see here, the elements of compensatory damages that can be claimed can include, of course, past and future medical bills, past and future lost wages. If an individual suffers some sort of disability as a result of the injury, permanent disability or disfigurement, then that can be compensated. Pain, suffering, and mental anguish, that can also be compensated. And property damage, lastly. Um, Past and future medical bills and past and future lost wages. Um, those are what we call economic damages. Um, and there seems to be a consensus that a wrongdoer should compensate a victim, certainly for medical bills and lost wages, if those can be appropriately documented. But there has long been, in negligence law, there's long been a disfavor in many circles, primarily insurance companies and corporations. They do not like to have to compensate individuals for disability and disfigurement and pain and suffering and mental anguish. And in particular, the pain and suffering and mental anguish thing is always under attack. The lobbyists have often tried to limit awards that a jury or judge can make for these categories of damages. These are what are truly called personal injuries. Some states actually have placed some limits on that. Illinois is not one of them. We have not gone down that road, then limiting the amount of money a jury can award for these types of truly personal injury losses. Okay, so keep that in mind, because that was an issue that we're going to come back and discuss in just a minute again with regard to Buffalo Creek. In fact, let me just do it right now, and let me stop the share. And let's talk more specifically then about Buffalo Creek. Stern had clients and the victims, I guess, of Buffalo Creek, and the individuals could kind of be broken down into three classes. And Stern had to deal with each one of these classes of plaintiffs a little bit differently, because legally their injuries, and factually too, their injuries were different. Okay, now the first group were always the most sympathetic. These were the folks who were present in the village of Buffalo Creek at the time the occurrence happened. And they also were caught up in the flood itself, the lahar, the water and the mud and the other debris the water flow had picked up. And actually would have suffered property losses, and had most likely suffered, they weren't killed or drowned, had suffered fairly significant injuries most likely if they actually got caught up in something like that and managed to survive. So that's the first group. And they certainly, I think, without any doubt would have had lost wages, medical bills, and would have had significant disabilities, maybe even some disfigurement. And those serious injuries and problems would have caused them real mental anguish and suffering, and we could understand some of the psychiatric, when you have these sudden traumatic events, we understand what we now know as post-traumatic stress syndrome. And maybe it wasn't so well recognized. I do not believe the book used that term, but clearly that the medical community now, looking at these individuals, especially in the first class, would have said that, yeah, it's not surprising that someone's still having nightmares and flashbacks and having problems concentrating and dealing with the post-traumatic stress that a trauma or an event like that can cause. The second class of plaintiffs, the first class being, of course, those were in the village and in the water and actually received physical injuries during that process. The second class that he had in recognized where they would have been in the village, but perhaps they were at high ground or managed to reach high ground before the water and the debris reached them. And so they would have been present in the valley. They would have witnessed the event, as horrific as that could have been. But they may even have suffered property damage losses as a result of the event. But they themselves were not in the water. They did not suffer physical injury as a result of witnessing the event. But they did, in fact, suffer psychiatric injuries. Again, the trauma of perhaps seeing your home, your friends, your family, their property, and their lives being lost can be a horrific, traumatic event. I think we all recognize that. And certainly, while you don't suffer any physical injuries, there's no doubt that you can suffer what? Permanent psychiatric injuries, as we now understand, can result in a diagnosis of post-traumatic stress syndrome. Lastly, then, the last group of clients he would have had were those that were not in the valley at the time the occurrence happened. However, their home, they would have returned to the valley at some point, and their home would perhaps be gone, or their families, some of their family members, including maybe children or things like that, could have been lost. And so while, again, they did not see the event, they weren't present when the event occurred, but nevertheless, because the event occurred, they had to deal with losses of friends and family and property. And again, can the trauma of those losses cause someone to suffer post-traumatic stress syndrome? The answer to that, of course, is yes. Now, this was problematic for Stern, and this gets into the last section of the last assignment of Buffalo Creek, Part 3. And this was problematic for Stern because there was some West Virginia Supreme Court cases, Davis and Montalone, that were discussed in Buffalo Creek, discussed in the text. Those two cases stood for the proposition that unless there was an actual physical injury, which could be, say, medically documented in some way by a physician, that is looking for some sort, really what they're saying is there's got to be some objective evidence of a physical injury. That in that event, then you can seek compensation for such things as disability, disfigurement, and pain and suffering. But absent that objective evidence of actual physical injury as a result of an event, of an act of negligence, and make sure you understand that that's the rule. This rule applies to negligence cases, that in the absence of that type of action with regard to the negligence cause of action, then that physical injury, that objective evidence of physical injury, absent that, then you can't get compensated for disability, disfigurement, and pain and suffering. Okay? And of course, the problem Stern faced was if that Davis and Montalone case applied strictly to his clients, 2/3 of his clients, and I think it was actually more than that. I think he did not have a whole hand, but a few of the clients were in the first category where they're actually injured in the water or drowned. I think those cases got settled pretty early. But it was the other ones, the ones that suffered solely the post-traumatic syndrome derangement as a result of the incident. Those were the ones that he was trying to get compensated for. And under Davis and Malone, it said, look, you weren't in the water. You're not going to get compensated for those injuries, right? So that was problematic for Stern. Okay, that was a big problem. Now, remember, look closely, that Davis and Malone applied to negligence cases. Negligence cases. Okay. This gets into the next question, is did the executives of Pittston and Buffalo Creek, were their actions merely negligent, or did they act recklessly? Recklessly. Now, remember, we've discussed recklessly already. That's the executive that does his due diligence, and all his due diligence says, no, don't do this. This is stupid. You're going to lose a ton of money. And he goes ahead and does it anyway, right? He goes against all the experts. And he looks like a genius if he wins, but if he loses, has that executive acted recklessly when, despite all the expert opinions telling him no, all the market studies, he goes ahead and does it anyway? Okay, that's acting recklessly. And if you act recklessly, we know that executive does not get the safe harbor of the business judgment rule, right? Yeah. All right. So the question becomes here, if these Pittston executives and Buffalo Creek executives acted recklessly, that's another level of conduct above mere negligence of breaching a standard of ordinary care and cautiousness, right? That's going above. And the rule is that when someone acts recklessly, we're not going to require the victims to show actual injury. Let me say it again, is that if you can show those executives of Pittston and Buffalo Creek, if Stern can do that, then Davis and Malone doesn't apply. Okay? If they only failed to exercise ordinary care and caution, he's got a problem. But if he can show recklessly acted, and we're going to talk about how that's defined legally, but if he can show that those executives acted recklessly, then those don't apply. And guess what? If those executives acted recklessly, then his clients that suffered only psychiatric injuries can now claim compensation. Okay? And so that's one aspect of recklessness. Now, let me go back to my torts PowerPoint real quick here. Okay, now, so we know if the executives acted recklessly, then you can get compensated for pain, suffering, and mental anguish. But there's another type of damage there besides compensatory in tort law, and that's the idea of punitive damages. Punitive damage. Damage is intended, what's the root word of punitive? It's to do what? Punish. And in certain cases, when the level of conduct reaches this level of recklessness or even intentional, they did it on purpose, that we don't have that, but can you make an argument that those executives acted recklessly? Yes. And in that case, not only if you can show they acted recklessly, can you get compensation for the psychiatric injuries only, but also you may be able to get awards of what we call punitive damages on top of that, in addition to that. Punitive damage as we suggested, are designed to punish an egregious wrongdoer, egregious, I like that word, an egregious wrongdoer, and to also make him an example, make that he or her, that bad wrongdoer, an example to deter others from engaging in that conduct. This is sometimes also called exemplary damages. And when the level of conduct reaches that of recklessness, and it really says reckless disregard for the safety of others, then Stern, if he can show they acted that way, reckless disregard for the safety of the residents of Buffalo Creek, then he can get around Davis and Montalone and get his clients compensated for those psychiatric injuries when they didn't have any physical injuries, and also may be awarded punitive damages to punish them. Okay, now, so it is important. What the upshot is this is that it's important for Stern to be able to show that recklessness for two reasons. Not just one, but for two. You get around Davis and Montalone, and then you have the threat of punitive damages. Now, let me tell you that punitive damages are the executives and corporations fear punitive damages more than anything else. It was the award of punitive damages by the plaintiff's asbestos lawyers that actually forced the discontinuance and use of asbestos. For the most part, it wasn't government regulation that forced it out. It was the award of punitive damages by juries all across the country against the manufacturers of asbestos-containing products. And the reason is because you can insure and you can buy lots of insurance, and it's relatively cheap in the scheme of things, for protecting against compensatory damages. And in fact, the asbestos industry, it turns out, had a whole bunch of insurance, because there's still insurance around as much, some estimates as much as between 20 and $25 billion in insurance monies have been put in trust. So for the victims, the continuing line of victims from exposure to asbestos. But what really executives pay attention to, and what the corporations pay attention to, are awards of punitive damages, because that actually has to be paid and can be collected out of corporate assets. I made my bones as an attorney representing individuals that had been occupationally exposed to asbestos, including mesothelioma victims. In 2000, I tried a case against, my partners and I tried a case against Shell Oil in Madison County as a result of a sheet metal worker being exposed in the 1960s to the asbestos while working at the Shell Oil refinery located in Wood River, Illinois. I got that individual to trial before he died. One of the things that the asbestos defense lawyers try to do is always delay things for mesothelioma victims, because generally they are dead within a year to 18 months after diagnosis. And of course, it doesn't take a whole lot of effort to delay a case of that magnitude for 3, 4, or 5 years before getting it to trial. But I managed to get a living mesothelioma victim. We had a system set up that allowed us to expedite those cases and get them to trial. And the reason why they don't ever want a victim of asbestos poisoning or lung cancer to go to trial is because while an individual is alive, the claim for punitive damage is a viable one. However, as soon as that individual would die of their asbestos-related disease, and then the claim for punitive damages disappears. And so if the defense lawyers can delay a case or a claim going to trial long enough that the victim eventually dies, then they have no fear of punitive damages. Families and the victims, heirs may be able to collect compensatory damages, but there's no longer the threat of punitive damages. In any event, I managed to get a living mesothelioma victim in May of 2000 to trial in Madison County. And I got an award from the jury of 9.1 compensatory damages, 9.1 million in compensatory damages, and got an award of 25 million against Shell Oil in punitive damages, and that they actually did. It turned out they actually did know of the dangers of asbestos exposure back when my guy was working there in the 1960s. And required him to use asbestos-containing products, but did not warn him of the dangers, nor did they require the use of any sort of protective clothing. Now, that was the industry standard and norm, but there was evidence Shell did that intentionally to shift the risk of asbestos use from their own employees to that of the outside contractors to third parties. And that was an industry-wide practice. So, and interestingly, through a set of fortuitous circumstances, I actually got to collect most of the money before Mr. Hutchinson died. So I'm crowing. I know. I'm talking about myself, my favorite subject. Yeah, yeah. So that's this idea of punitive damages. The Supreme Court's been monkeying around with them a little bit, trying to limit the amount of damages that can be awarded in any particular case. They took note of the fact, industry did, and their lobbyists, of the fact that the asbestos industry was bankrupt by the award of punitive damages by juries all over the country. And they have used the Supreme Court successfully lobbied the Supreme Court to take a very limited view of those now. It's much more difficult, I think, to have the kind of effect with punitive damages now that occurred in the 1970s and 80s with the asbestos problem. But we'll see. And so I think that's kind of where I'll leave it. I think I've discussed what you need to know and understand. And I wanted to bring this back to, remember that this idea about recklessness, it's a common idea in the law, and this idea of negligence, remember, also ties into the duties, those 5 duties that you owe your employer, because that's really what the whole idea of due diligence and the fiduciary duties that you as a manager with the ability to hire and fire board of directors and officers have, that you owe the corporation, and key employees owe the corporation. If you just look at that negligence formula and you plug your duty in, for instance, due diligence, if you breach that duty, your employer is injured, guess what? You got to pay compensation, right? And you all understand too, I hope by now, what is required to get the safe harbor of business judgment. Rule, buzzword. So I think I've now covered everything I want to cover. Does anybody have any questions? Anything they want to discuss? It's been a pleasure, folks. If anybody has any problems, again, let me know. Also, don't forget, just if you want to submit the Enron extra credit, some of you have already done that. Email that to me. I'll always ask for what it's worth. Generally, you do a good, credible job with Enron, it's worth 30 points. So there's an easy, free 30 points there for everyone. Okay, as I said, everybody good luck, right? Please do the best you can about trying to get online and evaluate. for me, please? And on the assessment section. I know I'm begging, please. All right, guys. Any other questions? No, I don't see anything else. I think looks like hi, Ryan, you're back now. Everybody done? All right. Good luck to you all. I may be on campus next fall. If I am, and you see some idiot with a beard, say hi. Walking around like he's lost. Okay. With that, we'll call it a night.